Let's get started. Just to remind everybody, my name's Keats Boyd from Boyd and Boyd PC. Today we're going to be talking about our 2025 amendment package. We did what I'm calling a pop-up webinar, just a short notice opportunity to go over what's in this amendment package. And I'm very excited to have so many of you just join on short or little notice. So thank you for taking the time to spend with me on this. We're going to be going over this amendment package, and there's an awful lot in it that we've tried to do to really add additional value to the trust program that we put in place for all of you. I'm going to go through section by section, but the big thing that we did was as a result of a divorce case about a year and a half ago, Jones versus Jones. Now, many of our clients have chosen to use the personal asset trust and the IRA inheritance trust because those two devices provide protection for an inheritance. They are really asset protection trusts. They they give protection from lawsuits, bankruptcies, tax liens, traditionally from divorce. But the Jones versus Jones case really raised some questions for us as to whether or not that's going to be an ongoing problem. Uh, so we are concerned about that and wanted to make sure that we address it. Now, the personal asset trust and the IRA trust, when it's designed, it's made for the child or the heir you leave things to and their descendants at the same time, concurrently. Your child has the ability to, as the trustee, to decide whether they're going to keep it for themselves or share it while they're alive with their children. And no matter what, when they die, it will pass to their descendants. Now, they have the ability to provide for a spouse if they want to, but what we saw was the Jones versus Jones case, at least in Massachusetts, created a problem for the divorce protection that we feel is so important. Now, I think the Jones case is distinguishable from the personal asset trust. The trust in that case was solely for the wife who was getting a divorce. Our personal asset trust and the IRA trust, as I said, is for your child and their children. But we are seeing the divorce bar treated as if all trusts are eligible to be divided as marital property. So let me go back and talk a little bit about the Jones case to give you the background. Essentially, what happened was a couple decided to get a divorce, and they were arguing over what should be included in marital property. Uh, the problem was the mother of the wife had created an irrevocable trust and put a piece of real estate, a home that the couple lived in as their marital home, but that home was owned by the irrevocable trust. There were also assets that provided the couple with income and the ability to take principal out, and they used that to maintain their lifestyle. So the divorce court looked at this and said, well, yeah, the trust is irrevocable. It's for the benefit of the wife, but because the couple is using it as a marital home and the assets are being used to support their lifestyle, we feel that that trust is really a part of the marital estate. And the wife appealed that decision. It went to the appellate court, and the appellate court came down with a similar decision that because her interest in the trust was solely for her, it was a fixed interest. They felt that the trust should be included in the marital estate because the couple used those assets for supporting their marriage. You know, living in the home, providing the getting income to maintain their standard of living and so on. So that became something of a problem. Now, the court stopped at saying that assets have to be taken out of the trust and given to the other side. They did not say that. What they said was, we're going to use the value of the assets in the trust to calculate the size of the marital estate. So just as an example, these aren't the numbers in this case, but just to explain it, let's say the couple had $1 million worth of assets on their own, and then they uh, had the trust that had $1.5 million in it. Combined, that's a total of $2.5 million. Now, during a divorce, there's something called equitable division of marital property, and the courts will generally say 50% of everything goes to each spouse. So if you're including the trust as a part of the marital estate becomes 2.5 million. Each spouse should get $1.25 million. So the result was the husband basically is going to get the $1 million, and somehow the wife has to get another $250,000 over to him. It doesn't mean that they have to take the money out of the trust or that the trust has to be held for the husband's benefit. It just means that somehow the husband's going to get $1.25 million. And so he's walking away with all of the true marital property, plus he's somehow going to get compensated the excess to make him whole. That is a problem from my perspective. And really, what prompted us to address this was the fact that in some cases, we see that the child of our clients who is going to be the beneficiary of a personal asset trust has no children of their own. And consequently, we want to make sure that those children have a way of naming somebody else to be a beneficiary with them. What we're concerned with is that the Jones versus Jones case really took away the divorce protection that we felt so strongly was available under the personal asset trust and the IRA inheritance trust. And now we need to take steps to bring back that protection. And to my mind, based on the decision in the appellate court in Jones versus Jones, the way we're going to do that is to make sure that there is never only one beneficiary of a personal asset trust. So we want to make sure that there are concurrent beneficiaries, so it can be your child and somebody else. If they have children, it will be their children, and they can decide whether or not to share that with their children because with a personal asset trust, they're the trustee. So we're using this approach to allow more than one person to get the benefits of the trust. And the change that we're doing is saying if the child doesn't have children, doesn't have any descendants, then they can nominate somebody to be a concurrent beneficiary with them. Maybe a nephew or a niece or a sibling or somebody else that they choose to bring in that they can share the benefits of the trust with if they choose to do so as the trustee. And that should be enough to stop this Jones versus Jones case. And if for some reason they don't name anybody, then we make it so that it could be any of the client's descendants that could be a beneficiary. So we're trying to make it so that there are always more than one beneficiary of any personal asset trust. And the trustee, which is usually the child who's the primary beneficiary for whom this trust is created, that trustee will be able to decide whether or not to share some or none of the benefits of the trust that you're really leaving for that child. But it gives them the ability to protect it from a divorce under the Jones versus Jones case. This can protect maybe as much as 50% of what you're leaving each one of your children. So it has a substantial value and a substantial risk protection that this language is going to add to your trust. And one of the reasons why we feel it's so important that you do update to get this amendment. And I see that I have another question here. So if my current PAT has two beneficiaries, am I protected? No. What I'm saying is you can have two children. Your trust when you pass away will be split into two separate trusts, one for each child. Let's say one of the kids has two kids. That child, because of the language, should be protected, but I can't guarantee it. And we think this additional language will help to ensure that protection. And there's another clause I'm going to talk about a little later that will bring additional protection as well. But this will start with that. But for the other child who has no children, The Jones versus Jones case could apply to that child, the beneficiary, your child who has no descendants, because they are the sole beneficiary of their pat as it was originally written. Once this amendment is added, then they have the ability to say, hey, I want to share it with my nephew or niece. I want to share it with my sibling. I want to share it with a charity. They can decide with whom they wish to share it and whether or not they actually do, but they should name somebody. And truthfully, let's say it's the child who has children. If they later get a divorce, it's always a good idea to have made even small distributions for the benefit of the kids. To take some of the money out and give it to them to help them pay for college education, help them buy uh, a car, help them pay for some expense that they might have. Instead of making a taxable gift, you can distribute out of a personal asset trust as a tax-free gift because that grandchild of yours, the child of your children, is a beneficiary of the personal asset trust with your child at the same time. Another question was, so each of my beneficiaries have children, my trust is protected. Maybe. Um, it's this case is the beginning of the court system trying to erode traditional law that says a gift in trust, an inheritance, should not be marital property. Traditionally, that is the rule across the country. But very often, when an inheritance is received, it's commingled, kind of like what was done in the Jones case. The property was used for marital purposes. And if your child, your beneficiary has children, even though those grandchildren are concurrent beneficiaries, but your child is using your trust to own a marital home, a marital vacation home, to provide for stocks, bonds, and mutual funds that are then used to support the marital home, it is possible that the Jones case could still apply to them. This language is one patch to make sure that there are always concurrent beneficiaries, so that there's always more than one, because we do see times where there are beneficiaries who do not have children, and we want to make sure we're addressing it. So this is one component to the cure for Jones. There's another component I'll talk about in a few minutes. That's another way to address the Jones case to make sure it is not a problem. Another thing you should be aware of that it hasn't come up yet, Jones only applies to beneficiaries who get divorced in Massachusetts. So if your kids live in another state, Jones might not apply to them. However, things will change. Uh, Courts that are looking for reasons to go away from the traditional rule of an inheritance is not a part of a marital estate will use the precedents of Jones in other jurisdictions. It is likely that this will happen over the next 10, 15, 20 years, that the Jones case will be used in other states that want to look at a case and say, well, maybe we should include what's in an irrevocable trust as a part of the marital estate because the beneficiaries are using it as if it is a marital asset, even though it's not owned by one or both of the couple. So, while it's right now only Massachusetts, I think it's important to address this for all of us, no matter where our children live, so that we are trying to do our best to protect against future changes in the law to make sure that the Jones case doesn't apply. One way is to make sure there are always more than one beneficiary. So, it's the gentleman who asked about if my beneficiaries have children, is my trust protected? Well, it might be protected for your children, but what happens when your children pass away and your grandchildren inherit? Will it be protected for them? And that might be a problem. It may not be protected for your descendants. Does the Jones case apply to a single person? No, it does not. Jones is about divorce. So if someone's single, it doesn't apply to them. But if they later marry and then try to get a divorce, the Jones case could impact whether or not your trust will be included in their marital estate. So I want to go back for just a second because I started to hit on something. You want to make sure that this isn't just about your children. Your personal asset trust, your trust is often designed to go to your children. And if something happens to your children, then it goes to your grandchildren. And if your grandchildren are married but without any children yet, and then they get a divorce, well, they are at risk under the Jones case. So this isn't just about your children. You have to look at this as a multi-generational trust. As weird as this is, we're kind of playing 3D chess with the courts to try to get ahead of them to make sure that we are looking at protecting your family, not just for you, not just for your children, also for your grandchildren and possibly for your great grandchildren. And so the personal asset trust, the IRA trust are multi-generational trusts, sometimes called dynasty trusts. They're intended to go on for a long time, and we want to make sure that we're providing protection for 90 to 100 years to make sure that nobody can reach into your trust and take the gift away that you're leaving your family. We want to make sure it stays with the people you intend to receive it. And so, one of the things that we're doing is we're plugging the hole by Jones versus Jones to make sure that there are always more than one set of beneficiaries at any given point in time for each line of descent. For anybody who's the primary beneficiary, one of your children or one of your grandchildren, we want to make sure that if they don't have children, there's a way to make somebody else a beneficiary with them so that the Jones case won't apply. Okay. I hope that's helped. I'm going to move on to the next slide, and if we have more questions, I'll come back to those at the end. All right. All right. The next thing we've added is a provision for a withdrawal protector. Now, this is something new and is really important for families that do not use the personal asset trust. If we have a trust that makes outright distribution, I've died, and when I die and my spouse has died, everything is given to my kids out of trust. They are the owner of it. It works kind of like a will. It's traditionally how trusts are designed. And so this outright distribution program is not uncommon, and outright distribution can create problems for beneficiaries who are going to receive those assets. But if we're making that outright distribution at an inopportune time, then is it going to be a problem for the beneficiary? Could they lose the gift that you're leaving them? Unfortunately, the answer is yes. If the trust says, after your affairs are settled, your debts and taxes are paid, divide the trust into 3 shares, one for each of my kids, and give to them out of the trust, free of trust, everything that they're supposed to get. And that is at the moment that they're going through a divorce, filing bankruptcy, getting sued for a car accident or some other problem we hope they never have. That could be a real problem because we're required to make the distribution out of trust to them. And that creditor, that problem in their life can just reach in and take the distribution away from them. A withdrawal protector can say, well, wait a second, this isn't the right time to give them their distribution. Let's do something else. Let's hold it for the time being, see if that problem goes away, and then we'll give it to them later. And so that can save maybe as much as 100% of the distribution. So for those of you who do not have a personal asset trust provision, basically you're saying, when I die, give my kids what they're going to get from me. Adding a withdrawal protector can protect them if at the time we're settling your estate and ending your trust, it can protect them from somebody else being able to reach in and take the gift away from them. Now, somebody else asked a question, could plugging the hole be challenged in court? So my dad used to say any idiot can file a lawsuit, but it doesn't mean that they have a case. Things can always be challenged, but by you as the donor creating a provision that says We want to make sure that this trust is not just for one person, that the Jones case should not apply, then you know, where you have that right to do that. You have the right to plug the holes that the law creates. And our job as good draftsmen, draftswomen for, you as your attorneys, we're here to make sure that we do try to plug those holes or find the loopholes from tax provisions so that your family pays as little and preserves as much as possible. Could that later be challenged? Yeah, if your child's spouse decides to file for divorce and wants to say, hey, this should be included under the Jones case, even though there are concurrent beneficiaries, I think they'd have a very hard time winning that case. Traditionally, let me step back. The personal asset trust is what's called a discretionary trust, meaning the trustee can decide when or if to make a distribution. And if the trust is written so that the distributions can be made to one or more people, the court cannot say, well, you need to give it all to the spouse who's getting a divorce. They can't interfere, they can't interject their own decision as to how discretion should be exercised. And so that's a real benefit because by saying that we can add more beneficiaries and now the trustee can decide to whom they're going to give gifts out of your trust that you've left for that person or their descendants, or they've added other people to be concurrent beneficiaries with them, they're the ones that can exercise that discretion. And the court can't say, well, we think you should exercise it differently. But as I kind of alluded to a few minutes ago, it is a good idea to show that you are going to exercise discretion, even if it's a small gift, to those other beneficiaries, to show that it's not just for you, that it's for other people too. And that will just build the case that this isn't just plugging the hole. This is actually being applied that way, and we're using it for the descendants of the donor in a way that benefits all of the pool of descendants, but primarily for the benefit of that child who you wanted to go to primarily. But if they want to use it to help pay for college education for their kids, to help buy that child a house, give them the down payment maybe, or give them some money to help come up with a down payment and do it in a way that's not a taxable gift, well, all the better. And then they can do some more on their own because they can then give up to $19,000 a year outside of the trust from their own assets. So it's really a great tool to make sure that we're going to be able to plug that hole, and it will be very hard for a court to challenge that. Can I guarantee it? Unfortunately, no. I'd love to be able to say I guarantee it. All I can do is say, based on the way the law is written today and how courts look at discretionary distributions, it's highly unlikely that a court would be able to say, no, you can't do it that way. Okay. All right, so that's going back to Jones for a moment. Then we talked about withdrawal protector provisions. Let's go back to that, and I'm actually going to move on to the next one. This is another attempt to deal with the Jones case, to basically say that we don't want to have um, the Jones matter uh, take away an inheritance from a child. And this provision is helpful whether you use the personal asset trust or not. So if you use outright distribution, this is going to be really helpful. If you use the personal asset trust, this one can be very helpful. It basically is saying that before any distribution, and we have somewhat arbitrarily put in an amount of $3,000, but we can tweak that amount. If before a distribution of X many dollars is made out of the trust, that beneficiary must have either a prenup if they're not yet married and they're going to get married, or if they are already married, they should get a postnup. A postnuptial agreement basically is saying, hey, if we later get divorced, this is what's going to happen. And the only thing we're suggesting be included in the postnup is not what happens to the child's assets in a divorce. It's really just saying we want to make sure that your child, and their spouse agree that whatever is in the trust will not be a part of the marital estate, and that will override the Jones case. Now, Sometimes that's a difficult ask to say to your child, hey, before you can get your inheritance, you got to go out and get your spouse to sign a postnup. And we recognize that. So we do make this clause optional. That if you want to include it, we can include it. And I lean toward recommending it. If you want to change the amount from $3,000 to 10,000 or $10,000 a month or whatever the number is, we can tweak that number so that there's still a back door so they don't have to go and get that postnup from their spouse. But we feel the postnup is another opportunity to prevent. Basically, we want to make sure that if you have either an outright distribution or even a personal asset trust, we recommend that your family, your children, and their children, ultimately, when they become beneficiaries, they post up with their spouse to address the Jones case. And as I said, we put in somewhat arbitrarily any distribution over $3,000, the post-nup, prenup is going to be required. We can play with that number to make the number a little bit larger, and that will help to give us other opportunities to uh, make sure that assets are protected and that the inheritance is not going to be considered a part of the marital estate. So that can protect, again, up to 50% of the intended inheritance. Another new provision is substance abuse. We've added a substance abuse provision. We don't see this happening too often, but occasionally we have situations where a child or maybe a grandchild develops an addiction issue, and we want to make sure that we don't have to make a distribution out to someone who will then later use that uh, inheritance to feed their addiction or their substance abuse problem. And so the a substance abuse provision basically means that the trustee can hold back a distribution for somebody who's battling an addiction issue. And that can truly be life-saving for that person because if they have unfettered access to the inheritance, it can be used to feed an addiction, cause them to maybe perhaps have some form of incident that could cost them their lives, or perhaps even something like a DUI that costs someone else their life. And so having this provision can truly be a life-saving provision. I think this is really important. It's something we really weren't sure how to handle before, and think that this provision is a really good way to address that possibility. A lot of making your trust is trying to deal with issues that we hope your family never has to deal with. But because we can't predict the future, your trust needs to be flexible enough to address these kinds of conditions, and adding this adds flexibility. You probably, if you've attended one of our walk through the trust seminars, you've heard me say, better to include language and never need it than need it and not have it. And this is another one of those provisions that really falls into that category. We feel it's important to include in the trust so we have a way to deal with substance abuse and addiction issues. But we hope we never have to use it, but better that it's there so that if it does develop down the road for a grandchild or even a great grandchild, your trust will be able to handle that in an appropriate fashion. Okay. Next, we added a definition. Now, you heard me say a few minutes ago that with a personal asset trust, the trust is written so that the trustee has discretion whether or not to make a distribution to any one or more of the beneficiaries. Discretion basically means that they can decide to give some or they can decide to give nothing. And we put in a definition not because we feel there's a lack of clarity as to what trustees' discretion means, but because we want to make sure that if a court is later reviewing this trust, very clear in the trust document that the court cannot replace what it thinks would be the right decision with what the trustee decided to do because we want that trustee to use their discretion. And courts have overwhelmingly, again and again, said the courts do not have the ability to replace their choice with the choice of a trustee. And so if your trustee decides that they want to share with their children, they can do that. Meaning the I want to say that differently because that might mislead some people. If you have a trustee of a personal asset trust, that trustee is also the beneficiary, the primary beneficiary of the personal asset trust, as are their children if they have any. And if your child, as the trustee, wants to share their inheritance with their children, they have the right to do that. They can decide and exercise discretion to share it, or they can exercise discretion to not share it. It is totally up to them, and a court cannot replace the court's decision with the child trustee's decision. So that's why I think this language is important to add to make sure that if we're looking at a court 30 years from now trying to decide, should we say that the child didn't do it right? Well, if it's a discretionary decision, the court can't change replace the child's discretion with what the court would use as its discretion. And that can save thousands of dollars in litigation expenses. So that's an important decision as well. So I think this is another great new clause. When we looked at the Jones case, which is what motivated us to make changes, we started looking around and saying, well, is there anything else out there that we really should be doing? And this was one of the clauses that came out to us, as are all these other provisions that we're talking about this morning. Okay. Next, late last year, we added option trading authority to our trusts. We're seeing an increase in use of options by financial advisors in areas that traditionally that options aren't used for. Historically, option tradings, puts and calls, are relatively risky trading strategies. However, financial advisors have found uses for calls and puts that are not risky, but in fact, really good tools. You can sell options as a way of raising income so that you're paid to protect, like I should say it differently, you're paid to hold a stock and unlikely going to have that stock called, but you get a nice income stream from it beyond the dividends that that stock will provide. And so using options as a tool to gather an income stream can be very helpful for those of us who are in our retirement years. Another use for options is as an insurance policy. Now, many of you might be familiar with a limit trade where you say, I want to sell my stock, but only if the stock market starts going down. And so if there's a decline by 10%, then go ahead and sell my stock. The problem is with limit orders, those can create a problem when the market's in a rapid decline. It will trigger the sale, but it may not necessarily sell for what you asked it for. You said, okay, let's say it's trading at 100 and sell at 90, but if the market's in a downward trend and goes down to 80, your sale may be at 80. Using options as an insurance policy, you're basically contractually binding someone to buy the stock from you at 90, no matter what it's trading at. Even if it's trading at 80 or 75 or 65, they're still obligated to buy the stock from you for $90 a share. And so having that insurance policy can be very comforting to know that should the market have a rapid decline, you at least are going to limit your losses. And so this is a good use of options. And so we've added an options trading paragraph, a clause that authorizes the trustee to use options trading, whether it's for raising income or limiting downside risk. This is, I think, an important addition to the trust. Doesn't really have anything to do with the Jones case, but it could really benefit you as the client because it can allow you to take advantage of these tools as ways of raising income or limiting loss in your portfolio. Okay, so this is a change that really would benefit you more than your heirs. We've added a paragraph within Article 11, paragraph 9. It's just a couple of sentences that encourages, I shouldn't say it that way, that makes it easier for anybody acting as a trustee of your trust, whether it's a spouse or a child, to bring in a corporate co-trustee if they feel that's going to be advantageous for the family. Corporate co-trustees um, have mixed reviews. Some people love them, some people dislike them. I find that there are times where a corporate co-trustee can be a real benefit to a family. They can be somewhat of uh, the the unbiased arbiter when families aren't always on the same page. They can make sure that the I's are dotted and the T's are crossed. There are times where most families will usually use a family member as a trustee, but very often those family members don't really know all the intricacies. Now, they can hire an attorney and get the help that way. But sometimes when it comes to financial management and making sure that the trust rules are being honored the right way, sometimes it's a good idea to bring in a trustee that's a corporate trustee. Maybe you've got a child who is in charge of another child's share, and it's creating a rift between the two children. Having a corporate co-trustee to be the one to make the decision as to whether or not distributions are going to be made might take the family member off the hook a little bit and make sure that we've got the right protections for the beneficiary who needs that guidance and the help, but it doesn't put your child on the line to be making difficult decisions. They can defer those decisions to the corporate trustee, and sometimes that helps to keep family unity, which is an important objective. It's non-financial, but very often we don't want our kids to, after our estate is settled, to never talk to each other because they don't like the way things went. And having a corporate co-trustee can take some of that risk off the table. So we've just added language here that makes it easier to add somebody if it's the right situation for your family. All right. Next, we've improved the subchapter S provision. Now, what is this about? Uh, Subchapter S is a form of tax treatment for a business entity. Historically, corporations can be taxed one of two ways. C Corp, which is much like your AT&Ts and your publicly traded stock companies, they are usually C corporations, where they file a tax return, pay taxes on their income earned, then they issue dividends to their shareholders, and then the shareholders have to pay tax on the dividend. Some people look at that as double taxation. And so small businesses may not want to be treated the same way as an AT&T. They may instead want to be taxed in a more casual way, that there's only one tier of taxes. So they can elect S corporation tax treatment, and it's small business is really what we're talking about here. Basically, it allows the corporation to be taxed as or more similar to a partnership, where if there's income at the end of the year, it flows through to the shareholders and they pay taxes on their pro rata share of the corporation's income. Now, why is this important? Well, not too many of our clients have corporations that are owned by their trust. But we're seeing an increase in the industry in the use of limited liability companies, LLCs. In fact, we are beginning to promote those to our clients. We're having a series of seminars. We had one earlier this year, and we're going to be doing them again in the month of June and July and throughout the year on limited liability companies as an asset protection tool for you. The last provision we talked about for the options clause, that's a provision that benefits you as the client. LLCs are an estate planning tool that benefits you as the client. And I think we're going to see an increase in those by our clients and in the industry as a whole now that the Corporate Transparency Act has really not going to be applicable to U.S. based small businesses. And so we want to make sure that if your LLC is taxed as an S corporation, we want to make sure that the trust is built the right way so that the S status won't be lost. If the trust owns a business that is an S corporation and has after your death, when it becomes irrevocable, it's possible that it could be written in a way that would change the eligibility for S Corp status. You have to meet certain requirements to be an S Corp, a limited number of shareholders, and a variety of other rules, but that's the big one. And when you have a trust that owns an S Corp and there's lots of beneficiaries, it's possible that we could exceed the limit of how many shareholders you can have. And so this provision basically allows us to make sure that we accidentally lose our S corp status, which could have a devastating income tax consequence to a family. And so we want to improve this language to make sure that it's very clear. We did have S corp language before, but this improves that language. Now, I'll be honest with many of you, when we set up clients, I generally look to be, well, I should step back again. LLCs can have four different types of tax treatment. It can be a disregarded entity, which means the individual who owns the LLC, the trust, or you personally, the income for the LLC on your personal tax return. It can be taxed as a partnership, which for real estate holdings is probably the best tool. Or it could be taxed as a C Corp, which has a tax rate of only 21%. So if we're not going to be taking income out of the LLC, being taxed as a C Corp might reduce the tax burden. If we're in a higher tax bracket, 22, 24, 32, 35%, being taxed at only 21% on the income, if it's going to stay in the LLC, might be a good idea. Or it could be taxed as an S corp. So all of those four different tax methods are available to an LLC. We just want to make sure that if it is an S corp that you choose, that the trust is going to continue to qualify for the best treatment for that S corp, and it's not going to have an accidental ineligibility and lose the S corp status, which would have a devastating income tax consequence. So now, what do we generally use? Most of our clients like the disregarded entity, only one owner, the trust, and it just reports on your personal income tax return. Or there's real estate or stocks and bonds inside the LLC, and we want step up in basis, in which case we tend to go toward a partnership. So you have to have more than one owner for that. So if you own 97%, you got three kids, and they each own 1%, you get a 97% step up in cost basis because it's taxed as a partnership. I'm a little bit off base on this, but I just want to again mention why this is important, because we're going to see, I think, an increase in the use of business entities as an asset protection tool for you, or as a tool for family governance, or as a tool to manage the family home on the Cape that we want to keep in the family for generations. Well, that's putting your kids and your grandchildren into a business relationship with each other, and it really should be governed by a business structure, and an LLC is the right tool for that. And so if you did decide to use S Corp status, we want to make sure your trust is still going to qualify after you pass away to be holding S Corp interests in a business entity. All right. So that's this provision. And as I said, it could save thousands of dollars in taxes through avoiding an accidental or inadvertent loss of S status. Another provision is the designated representative provision. This is new, and it came about because we saw some situations where we had family members who were troublesome or we had family members that would be disincentivized from going out and finding their way in the world. Let's talk about the second one first. You know, if we have a trust that's set up that's going to give a younger person a substantial inheritance, and they think, gee, you know, this is so much money. It's more money than I ever imagined. I can, live off this for the rest of my life. I don't have to go out and get a job. I don't have to make my way in the world. I can just be a trust fund child and I'll be a happy camper and enjoy life. That's not always the message we want to send. And so by having a designated representative, we have the ability to report information about the trust, not necessarily to the beneficiary, but to somebody else appointed to look out for the interests of the beneficiary. This way, they may not know exactly how much is in the trust and how much income is being generated. They may, it basically is designed to make sure they don't lose the incentive to go out and find what is their life goal, what is their life mission, and go off and do something and contribute and maybe make their own fortune on their own, but this will always be there as their safety net. So a designated representative, it comes out of the Florida Trust Code. It's something that is not seen in most states. It basically allows for the trustee to provide annual accounts and other notices to a party other than the beneficiary. And this can help, as I said, to make sure that the beneficiary doesn't feel like they can just sit on their backside and not go out and make it in the world. Another time where this clause can be very helpful is when we have a situation where there's a beneficiary or a guardian of a beneficiary who we think will make a lot of trouble for the trustee. I want to report every week on what income has been earned this week. I want information from you all the time. I want extra reports. I want distributions to add money to my house so that I can put in a pool. The kids will benefit from it, but it's my house. I'm the child and the in-law, and I want you to take money out of the trust for the kids and give it to me so I can do things for it. No, this designated representative can be used to appoint someone else so that that troublemaking guardian or overseer of a minor's interest doesn't necessarily have to be in the loop as to what's in the trust, how much it's earning. Someone will get that information on behalf of the beneficiary, but it doesn't necessarily have to be the guardian, the in-law. Sometimes it's the outlaw, the the divorced in-law, who's the guardian of the minor child. We don't want them to be able to gain access to the information. And so we can use these designated representative clauses to provide that additional protection that can be significant. We've added a new clause in Article 11 to say that the trustee can and should get the advice of an attorney. Um, Most trustees will do that, but there are times we've seen, especially with trusts developed by other firms where we're representing a beneficiary or maybe a co-trustee. We often see a child who thinks they are put in charge by mom and dad, and it resurrects some of those old sibling rivalry issues. Where they think, you're going to do it my way or it's the highway. You're not going to get your inheritance, and I'm not going to report to you. I don't have to tell you any information. And these are just creating problems and obstacles to getting the job done and done right. So this clause says, hey, trustee, get advice and counsel. Make sure you're dotting your I's and crossing your T's, that you're not doing something inappropriate. And if a beneficiary feels that the trustee is not doing something correctly, they can invoke this clause and require the trustee to once a year consult with an attorney to make sure that they are doing things correctly. And if they're not correcting those mistakes, this can save tens of thousands of dollars because it gives a beneficiary a way of resolving these disputes without the need to go to court, which will be a lot more expensive. And so this clause, I think, is beneficial to both. There we go. Thank you. Okay, I think that should solve the problem. I hope that did it. Thank you. The Scrivener protection provision is here to provide a tool to allow for correction of a trust that might be vague or have a typographical in it. It's a a drafting typo type of mistake that we can use the Scrivener provision to make a quick correction without the need to go to the probate court and say, "Hey, judge, this is what the donor intended, and it's just a typographical." Rather than going to court, we can make that more informally and do it in a way that will help protect the family and save, again, thousands of dollars in the need to go to court. So this is it doesn't happen very often. In fact, I've rarely seen this type of thing come up, but it's always a good idea to have that type of protection. Anything we can do to prevent the need to go to court is going to save your family thousands of dollars. We've improved the trust protector provisions. Now, some of these provisions relate to some of these other articles saying that we have certain powers to do things that we've outlined. The trust protector basically is the trustee with superpowers that they can do things that that your regular trustee can't. And so the trust protector provisions are intended to give us a way to either modify a trust or update a trust or provide other protections to make sure that a beneficiary doesn't lose their interest, that the trust is protected from outside influences. And so we've added three provisions to make those trust protector provisions a little stronger. And then the last clause I'm going to talk about is a dispute resolution clause. This is a whole article that we've added at the end of the trust. And if nothing else, I think this one makes it worth the entire amendment package just by having this. We all want our kids to work together and get along, but that doesn't always happen. And it may not be our kids, it could be the grandkids when the time comes that they are the ones that are in here and maybe doing things that can create some concerns. So we start the dispute resolution section with a reminder to the trustees. We want to remind the trustees that they are fiduciaries, that they should be taking things on in their capacity as a trustee to make sure that they're doing what's in the best interest of the trust and the other beneficiaries. In fact, we want to make sure that they are putting their interest second to that of the beneficiary. So the beneficiaries come first. What's in my best interest comes second. And we want to just remind the trustee of that with the trustee reminder paragraph. Next, whenever there's negotiations going on between trustees or trustees and beneficiaries, we all have to act in good faith. We can't be trying to sneak a quick one by the other side. We've added a provision that allows the trust protector to resolve disputes. This is kind of like a mediation clause so that we can bring on a trust protector, and rather than going to court to resolve a dispute, we can try to have a trust protector resolve that dispute for the family. This can save tens of thousands of dollars, and the trust protector will have the authority to make the resolution and do what is in the best interest of your trust as a whole. We've included a shotgun buy-sell agreement. Imagine a situation where we've got two or three co-trustees, co-beneficiaries that, they all have an interest in the trust, and there is a possession or a home or a business, and everybody wants it. One of the beneficiaries, one of the trustees says, "I'll make an offer of X amount of dollars." I'm just going to make up some examples here. Let's say I'm going to make an offer of $500,000 for that, but the property might really be worth $750,000. So they're underbidding the value of the property. Well, first, if they're a trustee, that's probably a breach of fiduciary duty. They're not negotiating in good faith. They're not remembering that that reminder that we had before. But let's say they make that offer anyway. What this does would then say, all right, the other side doesn't have to accept it. they can instead say, no, but I'll buy it from you for that amount. So that will stop someone from lowballing the value of the property. So this shotgun buy sell agreement is making sure that if somebody's going to make an offer to buy from the other beneficiaries, it has to be a true fair market offer. They can't underbid, and nor should they force the others to overpay. And so this is really something that this can work in both directions. You make an offer one way, you can be forced to have to work in the opposite direction. So you want to buy it lowball, you can be forced to sell it lowball. You want to force the other side to buy it for an overprice, you can be forced to sell it for an overprice. So this shotgun buy sell agreement is a really good tool to prevent that kind of misconduct by a trustee or a beneficiary. And finally, we've got a King Solomon committee. We can bring in outside parties again to do somewhat like arbitration. Again, the idea here is let's keep it out of court because court is really expensive, and this will provide a better result at lower costs by doing it this way. So these are all of the different things that we are working into this trust amendment. I hope that you've found this part of it helpful as a good explanation. And I'm just going to minimize one thing on my screen to make sure you guys don't have interference with this. But um, you know, just going over some of these key provisions. If you can look at this screen, you'll see that for each of these different provisions, there's a substantial financial benefit to you by having these provisions added to your trust. The divorce protections, Jones versus Jones, or the marital agreement, even the withdrawal protector provisions, that could save as much as 50% of a beneficiary's inheritance. And in the case of the withdrawal protector, it could be 100% of the beneficiary's inheritance. So, we put some lower numbers here just to make it, realistic, but, this could be a substantial amount of money that you're protecting by having these provisions added. Even the Scrivener clause, the dispute resolution, I'm sorry, the designated representative, this dispute resolution clauses, legal counsel requirements, if desired, those can save smaller money, but it's still a significant amount of money by having these provisions in the trust. And I think, having, as it says down at the bottom, an ounce of protection is worth more than a pound of probate. Many of these things, if we don't have these provisions, your family will be tied up in probate court one way or another, whether it's divorce probate or interpretation of a trust or trying to fix a trust or something like that. Is the trustee doing the right thing? Those are all probate court issues, and that's where your family would end up going if they have to have some form of court involvement. And we really want to avoid that because of the cost. So I encourage you to weigh that as a real benefit that we're trying to add to your trust document with this language. What's at stake if you wait? Well, if you wait and you never get around to putting these clauses in, your heirs could lose half their inheritance in a divorce. Without the Scrivener's clause, a small drafting typo could cause your family to have to go to probate court for interpretation of what is it supposed to say. Without the designated representative system, a minor or a difficult beneficiary could skyrocket the costs of settling your trust. And without the withdrawal guardrails, irresponsible heirs could jeopardize their future. And it's, as it says here, one bad decision by a court or one bad moment in your heir's life could erase decades of careful planning. So I think this clause is really, really important. All of these paragraphs can make a huge difference to your family. Um, uh, the planning here, I'll come to that question in just a moment. The planning that you can do by fixing your trust and making sure that we plug these gaps that were created by the Jones versus Jones case and some of these other things that we found to address issues that we've seen in practice in real life, I think will definitely benefit your family. If you're interested in protecting things now, to upgrade or update your trust to add the amendment, for our clients, it's a cost of $2,800. The folks who are on our estate planning maintenance program, they get a 10% discount, which brings it down to $2,520. You can order it online by scanning the QR code that's on the screen right now. It's not just about creating a legacy, it's making sure there's a firewall around it. We want to encourage you to act as soon as possible to get this amendment package in place. It's an important improvement to the trust that can save your family hundreds of thousands of dollars. And I think it's something that everyone who is an existing client should consider. Now, I've got a question in the Q&A. Let me go to that for a moment. Can the LLC versus a trust circumvent these issues you just pointed out? Unfortunately, no. So an LLC, I think you want to look at it as a structure, like a flow chart. An LLC is a business entity that can be used for asset protection for you and for your heirs ultimately. But how will they inherit your LLC interest? Generally, it's going to be done through your trust. And so your trust has to plug these holes the right way. Um, LLCs can add significant additional asset protection, but the ownership of the LLC is still going to be the issue. And so you want the ownership to transfer through your trust, and you don't want a divorce court or some of the other problems that we've outlined to be at issue when the interest is being transferred to the next generation. So, you can use LLCs to protect yourself from lawsuits, perhaps. I do this in our LLC webinar, and I'll make sure that everybody on this will get a link to the next one that we're doing. It's a couple of weeks out. But the LLC approach, basically, I think the perfect example of this is a gentleman who retired in Santa Monica, California. This was back around, I think it was 2003, I believe. He was driving one afternoon downtown Santa Monica, bumped into the car in front of him, went to hit the brake, but accidentally hit the accelerator and drove his car through a farmer's market that was just beyond the intersection where the accident occurred. Drove through at high speeds, 50, 60 miles an hour, killed 10 people and injured another 70. Damages, I believe, were somewhere around $12 million in 2003 dollars. Today, it would be like 20 to $30 million worth of damage. An LLC is a way of trying to make sure that you have a safety net so that nobody can break through your revocable trust and take away everything you own. A revocable trust for you while you're alive does not give you any asset protection. When you die and your trust becomes irrevocable, it can give your children asset protection if you have the personal asset trust built into it. But while you're alive, asset protection for you needs to come through tools like an LLC, a domestic asset protection trust for non-real estate holdings, or a spousal limited access trust, maybe for Medicaid planning. If you think you might need nursing home care, a SLAT can be a good tool to provide asset protection. So an LLC won't circumvent these, but it gives you the ability to protect what you have and make sure there's some form of safety net, and that it's very difficult for somebody to break into your LLC and take things away from you that you want to keep and preserve. Whether that's an investment property, a stock portfolio that you live off of, LLC is a great tool for our clients to provide asset protection. I get into that in much greater detail in that LLC webinar. We'll be putting an email out about that a little bit later in a week or two. Once we do have a date on the calendar, but I don't have it in front of me. So that's a great question, but I'd encourage you to, oh, there's another one. I just closed the window. Bear with me again. Q&A. What is the mechanism that protects assets from nursing homes? All right. So um, traditionally, Medicaid planners, a practice that I am not a big fan of, will have you give everything away now so that in 5 years, you don't own anything and you're poor and can go on a welfare program called Medicaid. These types of trusts are called Medicaid planning trusts or irrevocable income only trusts. The only thing you ever get from your assets are the interest dividends and the right to live in any real estate or the rent that real estate can generate. And everything else you are forever forbidden from being able to access. I don't think that's a good plan for retirement. And to me, it's something to think about when you have a diagnosis of MS, Parkinson's, dementia, Alzheimer's, something where you know a nursing home might be in your future. It might be a good idea to consider that type of trust then. For my clients, I much prefer something that we are just looking at and haven't, honestly, I haven't really put this out to anybody yet. There is a special type of trust that we've talked about mostly for estate tax avoidance called a spousal limited access trust, or a SLAT for short. It's something akin to the credit shelter trust that's built into most revocable trust. When you die, we can shelter up to $2 million from the Massachusetts estate tax in a trust that basically says income to the spouse for life, and they have access to the principal for reasons of health, education, maintenance, and support. So it's not owned by the spouse, but available for the spouse. And slats can be built to mirror this and do it while we're alive, and then we get to do it again when we die, and still shelter another 2 million from the mass estate tax. But the slat is a tool to create a gift for our spouse while we're alive. Now, a slat can be written in a way that will work under the Medicaid rules. Income to my spouse for life. Principal at the discretion of a trustee who is not my spouse. So we can create a slat for our spouse and make it so that it is not subject to the claims of Medicaid if that spouse later ends up in a nursing home. It also will work if the spouse who made the gift ends up in a nursing home. And we still have to meet the Medicaid requirements of having no more than $2,000 for the spouse who's in the nursing home and no more than around $150,000 for the spouse living at home. So we have to structure our affairs to make it work. But a spousal limited access trust is a better way to do that in my mind, because we can make discretionary distributions for more than the income only. So we can get at the principal while we don't need nursing home care. We can have the trust buy into a assisted living community, for example, where a Medicaid trust can't. So we have a number of benefits that we can use this trust for. It will work better in many cases under the Medicaid rules than your traditional Medicaid planning trust. I generally discourage that type of planning until we have a diagnosis, and then we usually have enough time to do planning after that. But if somebody who wants to be doing the planning now, a SLAT, I think, is a better alternative to a Medicaid planning trust. Okay. So those are great questions. If anybody else has a question, now might be the right time. I've gone a little longer than the hour we anticipated, but I'm grateful for your attendance and patience as we work through a couple technical problems here. And I hope you found this educational and informational. You can scan the QR code that's on the screen and go right to our purchase site for the amendment. If you have a personal asset trust or a basic trust, you can get this amendment for $2,800. Or if you're on our maintenance program, it's $2,520. If you want to join the maintenance program, it's $497 to join the maintenance program. That gives you 30 minutes a year of time that won't be billed at our regular hourly rates. And it gives you a document vault where your documents will be digitally available to you through a secure username and website that you will have access to. You can add additional documents to that if you want to. It also gives you a 10% discount off any service that we offer. And then finally, it also gives your family a 10% discount if they choose to have us help them with their estate planning. So you put your trust together with us, you want your kids to suggest they do that, they get the 10% discount because you're on our maintenance program. We're also offering a special discount for people who are on this pop-up webinar If you have our simple plan, or if you're not one of our clients and want to move over to join the Boyd and Boyd family for estate planning, we'd love to see you join us. And what we're offering right now is a cost of, I think it's roughly $6,900 to get our full personal asset trust based estate plan. That's a steep discount off our regular cost. It's savings. If you're on the maintenance program, the savings are around $5,200 to get this. So if you're not a client of ours and would like to join our client family, we'd encourage that and welcome you and give you this great financial incentive to do that. So you can do that by clicking on the website, going to using the QR code. If you want the maintenance program, check the box at the top to say you want to join it. If you're already on it, you do not need to do that. You're all set. And just take advantage of the EPMP discount that's available. If you're not going to join the maintenance program, check option 1 to just get the amendment. If you're on the maintenance program, it's option 2. If you want to upgrade from a simple trust to a personal asset trust, we're giving you a really inexpensive opportunity to do that. And if you're not a part of our client family yet, want to join, we welcome you. And that is either option 3 or 4, and depending on whether or not you're adding the maintenance program as a part of your purchase option. So with that, I'm going to just look to see if there's any more questions. Thank you all for joining. If there are any more questions, I'm happy to answer those. And if not, then I hope you all have a great afternoon. I will be making this recording available if you want to rewatch it, but I do have to do a little bit of editing, so it probably won't happen today, but later this week you'll get an email with a link to this recording. If you have questions, it's okay to reach out. Understand that we do get a ton of email here, and sometimes we're a little slow in answering. I just want to forewarn you, but I hope that you'll take advantage of this package. It is really important. I urge everybody who's a client of ours to get that amendment package at the very least. And if you're on the simple plan, to take advantage of special upgrade pricing that's really discounted, substantially discounted from our normal price. Consider doing that. And again, if you have any questions, um, oh, I see there's another question that I missed. Bear with me for just a couple minutes. What if a beneficiary spouse refuses to sign a postnup? Does that block major distributions? The way we have it written is yes, it will. Now, there are a couple of ways around that. If you're concerned that a child will have that problem, or you want to give your child a backdoor to make to get larger distributions, we can do that by changing the amount of the distribution and saying, right now it's just any distribution of $3,000 or more has to have a prenup or a postnup. If you wanted to say instead, X amount per month or a total of $100,000 a year or something like that, we can tweak it a little bit to give a backdoor to your child so that they can still get access to the funds. But if a spouse is not signing a prenup or a postnup, then you're going to have the issue of will the inheritance be a part of the marital property in a divorce? Now, again, Jones versus Jones right now only applies to children getting a divorce in Massachusetts. But I foresee this expanding into other states as time goes by. So we'll have to wait and see. I could be wrong on that. I kind of hope I am. But the prenup postnup is another way of just trying to lock down the inheritance to make sure it stays with the family. All right. Another question was, what mechanisms protect assets from nursing homes? That is a 2-hour lecture all by itself. Generally speaking, most people use the Medicaid Planning Trust. There are a few other devices like certain types of immediate annuities. The SLAT that I'm more in favor of. Occasionally, life estates can be used, but I find there's a lot of risks with life estates. To me, that's what's right depends a lot on the facts and circumstances of the family that is facing a nursing home stay. And so, the problem with nursing home planning is you're planning for a stay in a nursing home. Now, if you could, I mean, there used to be a raise your hand feature here, but I'm not gonna, I won't do that. Most people, if I asked you, do you want to go to a nursing home? Most people are going to say no. And so my next question is, then why would you want an estate plan that's going to force you into a nursing home? Now, if there is a diagnosis, then yes, we want to address that and try to find the right approach for you and your family. But the truth of the matter is, most people, before they go to a nursing home, will want to stay in their home as long as possible, or will want to go to an assisted living community. And the plans that allow for Medicaid planning for nursing home costs, generally do not provide a tool to pay for those other approaches. The other thing that I didn't mention as a tool is long-term care insurance, which to me makes a lot more sense for most people, but it's very expensive. But would you rather pay, you know, a fraction of a percent of your estate size annually as an insurance premium, or would you rather give everything away? The average cost of a nursing home stay is about $150,000 a year right now, at least in this part of the country. And the typical stay is a little more than 2 years. So you're talking about $300,000. If you totaled up the entire value of your estate, everything you own, your retirement accounts, your life insurance, your real estate holdings, your investment accounts, your savings and bank accounts, you tally all of that together. Does it make sense to you to give all of that away to save $300,000? If you answer yes, then traditional Medicaid planning is a good approach. And I might not be the right person for you. We can do that kind of planning, but I want most of my clients to be very careful before they do that. I want them to be very sure because when this type of planning is done right, you cannot undo it. You're stuck. And if something happens and you need to change your mind, you can't. And so that's why I don't like that approach. I prefer long-term care insurance, the idea of a slat, and maybe waiting until there's a diagnosis, because then we know we're going to have time to deal with it and work out ways of planning for staying in the home or paying for assisted living communities where Medicaid planning, if you do that ahead of time, you won't be able to use those options. And so it's something to be very cautious about. All right. So, anyway, I hope that answers all of the questions. What if you do not require all of the amendments we discussed? We do it as a package because we see this as maybe it won't apply to you today, but it might apply to your kids 30 years from now. And so we think it's, as I said earlier, what happens if we're better to include language and never need it than need it and not have it. Okay, so my answer to that question. I hope I've answered all of the questions. It's possible that I've missed something, but I don't think that I have. Oh, here's another one. Will I email a summary of the slides? No, I don't do this, but I will get something out to everybody as soon as possible with the information about the how you sign up and that kind of thing. But again, pull out your phone if you have a chance, scan the QR code. That'll bring you right to the website to place your order for the amendment package. Or if you want to do an upgrade to go to the personal asset trust, or if you're not a client and want to become one of our clients, you can use that order form to place your order today if you'd like to do that. Again, I think I'm going to wrap up at this point. If you I hope you've gotten some great information today. And thank you very much for spending some time with me in this pop-up webinar. With that, I think what I'll do is end the webinar for everybody. And if you want to make sure you have a chance, go sign up for that amendment package. We'll get that prepared for you in a couple of weeks, have you come in and sign it, and your estate plan will be strong for the foreseeable future. All right. Thank you, everybody. Have a great afternoon. And again, thanks for joining me for this pop-up webinar.